Did your loved one die leaving a handwritten will? Are you unsure what makes a handwritten will valid? Well, let's discuss how to figure that out. Hi, I'm California probate attorney Scott Grossman. By the end of this video, you will understand what makes a handwritten will valid under California law and two common misconceptions concerning handwritten wills. A handwritten will is also called a holographic will in California. Now, I know that sounds funny and people hear holographic and think it's a Star Wars or a Star Trek reference. I know it's a silly name, but that's just what it's called, and I've got no idea where the name holographic will comes from. There are only two requirements that have to be met for a handwritten will to be valid under California law. First, the will must be signed by the testator. It really is as simple as that. Now, it can be signed at the top of the page, the bottom of the page, or the side of the page. It doesn't matter where it's signed as long as it's signed. It could be that all the provisions of the will are written on the front of the page and the signature is on the back. That's fine too, as long as that will has been signed by the testator. The second requirement is the material provisions of the will must be handwritten by the testator. Now, there is nowhere in California law that defines what constitutes a material provision of the will. I can tell you in my experience, it really doesn't matter. And the reason is this. You're either going to find a will where either the entire thing or very nearly the entire thing is all in your deceased loved one's handwriting, and that makes it valid. Or you're going to find that nearly the entire thing has been typed, except perhaps for the signature of the testator. And if nearly the whole thing is typed, then it's going to be invalid as a holographic will. There are two common misconceptions surrounding holographic wills. The first of them is that the wills have to be witnessed. That is not true. A holographic will has just the two requirements I told you about earlier. It's got to be signed by the testator and the material provisions have to be in the testator's handwriting. No witnesses are required. Witnesses are required for typewritten wills, but that's a completely different discussion. Holographic wills do not require any witnesses, period. The second common misconception is that a holographic will does not have to be dated. Now, it's not a good thing if it isn't dated, but I want you to understand it's not fatal. Here's the potential problem if the holographic will isn't dated. If the testator at any time before they died became mentally incompetent, there is then a presumption that they were incompetent during the time that the will was written. The length of time your deceased loved one was incompetent doesn't matter. There's going to be a presumption that they were incompetent at the time the will was written. Now, there are all different reasons that a person becomes incompetent. Sometimes people have vascular conditions that can be cleared up, so it's a relatively short period of time that they were incompetent. For other people, it's a more serious condition like dementia, which is permanent. Whatever it is that's happening in your case, if there's no date and there was incompetence, then you're going to have the burden of proof to show that your loved one was in fact competent when the will was written. It doesn't matter which it is. If the testator was ever incompetent, then the presumption applies. If you want the will admitted to probate, then you have to prove the testator was competent when the will was written. There's another potential problem with an undated holographic will. If your deceased loved one has another will that's got a date on it, then there's a presumption that that dated will is the one that takes precedence. If you want the holographic will to apply, then you will have to prove that the holographic will was written later in time than the dated will. If you're ready to start your case, then give us a call or visit our website to fill out our contact form. If you aren't yet ready, then go to our playlist on probate or probate litigation to get even more useful information about your situation.